In that process, once the city had reached a recommended sentence, they would then not have witnesses appear at the hearing, and I understand that that may have been a change from the past. So these were some of the things that came up, and in talking to the city prosecutor, she also indicated to me that we really didn't have any guidelines, and that may be something we want to look at in terms of she couldn't find any sentencing guidelines for first-time offenders, second-time offenders, that kind of thing. So she was just working off of historically what had happened. And so maybe council may be interested in looking at some changes on that. And then in addition to that issue, there is a mechanism to do a fine in lieu of a suspension. So if a applicant comes forward, the citation is sustained, which means it's found that they did violate, then at that point the applicant gets a sentence. Let's say it's a 10-day suspension. Maybe 5 of it is suspended on the condition they have no other violations. In many jurisdictions, if it's your first offense, they allow you to pay a fine in lieu of that suspension. That's not something that we do in Littleton, and something that maybe the council wants to look at, or maybe the council and the licensing authority thinks it works fine the way it is. And then the other issue that we had were costs associated with these hearings. There are no costs, is that right, Rochelle, on a show cause? Right. So where you see the court imposing costs on any defendant who comes in, and many other jurisdictions assessing costs for these show cause hearings, we have no costs. So potentially somebody, I guess to simplify it, we have an establishment that, let's say, sells liquor to a minor. They come in on a first offense, they get 5 days suspended, no costs, and they're out the door. That seems to be a pretty lenient sentence in terms of looking at where other jurisdictions are and having no costs associated with it, when in fact there is much staff time that is taken and much board time that is taken to put these hearings forward. So those are the issues that we've outlined, and then I think one of the other board members sent in a question that I'd be happy to answer also that couldn't be here. Is that right? One of them can't be here.
Yeah, Earl Green is not here, but
give her a microphone.
Member Odell requested a discussion about the neighborhood petitions. I think that's something that's really not necessarily a policy issue, but something that the licensing authority can do. But he had some concerns, and maybe you want to explain your concerns about the timeline for submission, because they're not getting into your packets until the night of the meeting is. That's right.
Yes, thank you. I had a concern because one of the legal requirements for obtaining a license within the city of Littleton is that a petition be circulated with it is a defined legal neighborhood for the licensee, and that those signatures then be presented to the authority, and the results of those are a determining factor whether that license is granted or not. However, when we have been receiving this petition is right when we sit down and begin the proceedings in the form of an exhibit. We don't receive them in our packets. On one occasion, this has been, I think, about 2 years ago, when then Authority Chair Tony Gallagher found a number of signatures that were non-correct. They'd actually been standing outside of a Home Depot to gather these signatures, figuring these people must live in the neighborhood. On questioning Member Gallagher, how did you catch this? He said, well, I've worked in the post office for a number of years. I have this skill set. A couple sessions ago, Authority Member Cole found a signature that was not in compliance, but it's very difficult without a specific skill set to just receive those signatures and seriously meet your obligations as a board member to make sure that those signatures are within that neighborhood. So what I have learned since then, that because I wasn't sure if it was a matter of regulation, a matter of law, or specifically what the requirements were for submitting those, and I have learned now that it's pretty much a procedural one. I believe the authority probably can direct the city staff in a manner that they will be able to receive those signatures in a timely manner, because a lot of times they receive them Friday before those packets are to be sent out. They don't get them out to us. They're just not able to. So if the clerk's office or procedurally we can find a way to have those petitions into the clerk's office so that they can be into our packets, then I think that adequately addresses the question of our examining the signatures.
Well, this may be the easiest issue all night.
Let's do it.
Can you guys make that happen?
Got it.
Okay, good. That's done.
That's all.
Yeah. So, stipulations.
So there's a few different ways that, we could go with this. In the opinion of our office, it's more efficient to do things by stipulation, because then the parties know what they can expect, and there's less of a chance for a hearing, which brings down the costs, including the officer overtime. And in many cases, kids who are minors but maybe going to school out of state who help participate in a compliance check when they were in town wouldn't have to be subpoenaed back into town. So we would like to continue that process, but if that's not a process that the authority or the council wants to support, we could go back to not entering into any negotiations and allow these cases to go to hearing. The other sort of mid-between thing that we could do is we could do a preliminary hearing where, maybe you can explain that one better.
Well, it would just be a preliminary hearing where we wouldn't call. Oh, I'm sorry. Where we wouldn't call in witnesses at that time, and so they would just be discussing the stipulation. So they'd just be voting on whether they're going to accept the stipulation as it is, or whether they're going to set it for a show cause hearing, and then at a later date bring in the witnesses.
Peggy?
So I was at the meeting that Suzanne watched where some of this came up, and so I heard some of the discussion by the authority there of why they wanted to continue doing what they had been doing. So I'd like you guys, if you would, to share your thoughts on this for the whole group. You know, what you would like and why, if both.
The authority didn't have an objection to the stipulations as such. What struck us that particular meeting was the fact that all of the cases that came before us had already been settled in stipulation, and we were used to actually going through a hearing and listening to testimony and making a decision based on that. And we think that's been very effective, that we did that, the deliberation and the whole package. And then all of a sudden in one meeting, we didn't have much to deliberate because everything had been decided when it came before us. And we were a little bit shocked by that, and our concern was, is this the way it's going to be all the time? In which case, do you really need a liquor authority? And that's where we left it. I've had conversations with Peggy about that, and I think if anyone else on the authority wants to talk about any of that.
I probably should, since I'm the one that made the big fuss. But I will say there's one thing that you said, Suzanne, that is not accurate. Before, when Alan was the advisor, he actually would not make recommendations. There were very many times when he would reach an agreement with whoever had violated, that there was a violation, and then always the penalty was left up to the commission. And in fact, he wouldn't make a recommendation. He felt that that was the commission's job. And we, I think, looked at the code where it says we're supposed to listen to evidence of aggravating and mitigating circumstances, and we did do that. And these aren't huge hearings. There aren't hundreds of witnesses. You know, there's the police coming in if it's a sting and saying this is what happened, and then the liquor store or whatever would present their own evidence. But all of a sudden, the change is not only is there a stipulation as to whether there's a violation, we're presented with a whole stipulation in writing that even has the penalty in it. And you can say that we, as the commission, can overturn that, but I believe that the people who sign that stipulation, the liquor store owner, have a reasonable expectation. There's negotiation, there's back and forth. So really the expectation is the commission is going to rubber stamp it. And I think that is a huge change. And if that's a change, the council wants to make, that's fine. But this occurred, at a meeting where all of a sudden all we're getting is stipulations. And I understand as a lawyer that if you're negotiating for your party, that you want to negotiate both the penalty and the violation. But prior to that, people were stipulating to the facts. And then there are guidelines under the Colorado Department of Revenue does have sentencing guidelines. And I don't believe that we've ever veered from that. So, I guess our question was, is there a problem? Were there a lot of complaints? Did people feel they hadn't been dealt with fairly? Because, it was just such a big change.
I don't think it was anything that was a problem. I think that what happened was the prosecutor came in and, as you know, she's in 12 other jurisdictions, and we've surveyed some of those about how they operate. And so she came in and she just looked at the cases the way she does in other places, and there's a written stipulation with a recommended sentence. And when I watched it, those applicants who came up did all say, yes, I was told by the prosecutor that this may not be the sentence. So I don't know that they had an expectation that it was a rubber stamp. She, I had talked to her that she needed to explain to them that, this was only a recommendation. The stipulation did not include the sentence.
But I assume that there were negotiations back and forth. Maybe they said 1 day, and she said, no, 2 days, and they had negotiated, a sentence. And then I think when we're presented with a written stipulation, we feel like it's harder for us to really look at the aggravating and mitigating circumstances.
Well, and I think that, that's fine. She's just looking for some direction on, if you want it done differently than she's used to, but the same that we've been doing it in Littleton, we can continue that. I think that the witnesses probably were not subpoenaed in those kinds of cases where there was a stip to the facts.
No, generally, I think what would happen is they would come in and tell us.
Volunteered.
Yeah.
And have volunteers, and they're not sworn, and.
But do they show up at those?
No.
They have.
But they weren't that night. That night,
No.
the primary witnesses weren't there that night that I attended.
Right, but in the past, he's reached a stipulation but still subpoenaed witnesses?
No, what would happen generally is there'd be a stipulation as to the violation of the code. And then they would tell us, either through lawyers or the owner, what they had done, what changes they had made, what the mitigating circumstances were, and then Alan would present his, basically just give and take, and we would make a decision.
And he would make a recommendation. We could accept or reject his recommendation.
No, actually, he didn't. He
It
wouldn't.
wasn't in writing. It wasn't fixed that this is implying that this has been decided. It was just a vague suggestion.
I guess we just took it seriously. We looked at the mitigating circumstances, and we felt like all of a sudden we were just being asked to,
Let me give you an example of something that came for us with mitigating circumstances. If you look at the surface, it's extremely serious. The police were doing a sting. They went into the establishment. It was a retail liquor store. And within a period of several hours, the same clerk, or maybe it was actually within a couple hours, the same clerk had sold to 2 underage individuals. That's serious. On examination, this was a liquor store that usually is busy, but this was really, really busy. The young man was of age and able to do this, but this wasn't his job. His job was usually filling the coolers, and this is what he did. So he'd been placed in a position that he just was not used to fulfilling this role within the store. And he did make the mistakes. But the owner of the store came and explained, you could tell from the young man that he was sincere, he was embarrassed. On top of this, the store said what they were going to do to rectify this situation is you can purchase a mechanical device that scans cards, and it can tell from every state whether that this is a valid license or not. It is extremely accurate, and it is a fairly expensive item, and they were going to install it. So you could see that they were going to genuinely make an effort to rectify that this kind of situation couldn't happen within the organization again. Well, those were mitigating circumstances that we took into account, and it did make a difference. The one other thing I would say is we know, even though you can tell an individual that the authority does not have to accept this, but we all know that in business, in education, a number of different disciplines, the act of saying something, seeing something, and then having it written emphasizes this and locks this one more into one's mind, expectations. And what we have here is just not even a written stipulation. It is a licensee then signing that. So I think the authority members think that despite what appears on paper, that a expectation among that licensee is heightened, and we just don't think that that's appropriate since things are going along so well as far as maintaining proper conduct among businesses that have liquor licenses within Littleton.
Bill?
I'm going to try and synthesize some of what I've heard and throw at least an idea out and see where we might go with that. Certainly, the reason why we have a licensing authority rather than abdicating it to somewhere else, it's our community. It's our neighborhoods that are here. It sounds like we had an implementation of something that fits an interest that we share. How it did it, I don't know, but of some level of efficiency and inconvenience or avoiding inconvenience to some of those folks that have been helpful in the process, witnesses and police officers. And what happened with the written stipulations, at least as I'm hearing and I've observed, is, yeah, it kind of went in a direction. Okay, we didn't have to have the witnesses there. We didn't have to have the police officers there. The question that I have is, Kirsten, you mentioned the possibility of having an informal hearing that essentially could be doing some of the same things without necessarily putting in writing a commitment, allowing for folks to come forward and share whatever might be mitigating. If there's something that folks would like to share on the aggravating, whether or not that gets at the table or not, I don't know how often that comes up or doesn't come up. If more of the standard operating process would be to have the informal with a discussion and I don't know, Susan, if a recommendation from the prosecuting attorney kind of says, okay, without putting it in writing, would be something that would be okay to say, hey, we've discussed this. We're going to get to the guidelines part, which may have some elements in it that would provide some guidelines with that. Is that something that the authority would, or members of the authority would think, hey, that kind of sounds like it might fit in from the attorney's office, is that something that would be workable to get us to the efficiency level we're looking for, but also allow for kind of our community input?
Well, and that is why we looked at that option that is utilized by some other communities as sort of an in-between stage where you can have that discussion, and then if the parties aren't in agreement with what the penalty would be, then it would go on to a hearing, and we would know that that hearing was going to be held, and we need to get the witnesses and...
Let me just ask, can you start the informal and still end up with a resolution?
Yeah.
Absolutely.
Right, so
So
we,
you aren't necessarily using a whole lot of time?
No.
But you're, okay, good.
One of the values that I see to our public authority meetings is the fact that they are public, and there's a high level of scrutiny to licensees to behave themselves. And if they work behind the scenes and pay their penalty and then come to a meeting, don't even come to the meeting, but their representative comes to the meeting, that's different than if they have to stand up in front of the whole city of Littleton and explain why they did what they did or didn't do what they were supposed to do. And I think that's really the crux of the matter as far as we're concerned is let's have this thing public and have the motivation to stay away from that public meeting by having a violation. So we could do both things with what you just said.
How many cases are we talking about?
Let's see, so far this year, we've done maybe 4, and the year before, 13 in 09. Oh,
13
continued.
total liquor license violations.
16 in 09.
16 and 09.
Yeah, and then in 2010, there were 4.
There were only 4 in 2010? We're
So
not
far this
talking
year
a whole
there's
bunch
4?
of cases.
So far this year, yeah. No, it depends how many compliance checks PD gets out and does.
And I would say the ones we've dealt with in the past year, especially the last 3, they were pretty obvious. There was a police report, it was a compliance check. Someone underage walked into a store, gave them an underage ID, and they sold them liquor. I mean, those kind, I would think, there's not a lot to stand on to debate it. So a preliminary hearing, I think, would serve that purpose because the people don't seem to have a problem with the facts of the case.
No, and that's what I'm saying. That's why normally when it's a sting, they'll stipulate, yes, we did this, and then throw themselves, give us the facts and the aggravating and mitigating circumstances. So, we have had some pretty interesting ones in the past where they were full-blown hearings, but it's been a long time. So.
Bruce?
Yeah, I'm going to suggest that this pretty clearly is, I think to Bill's point, the public nature of this thing and the process, notwithstanding I respect the intent in terms of efficiency, but I guess maybe I'd sacrifice some efficiency in this case for the process that you guys are doing. You guys are pretty clearly a high-performing board that's serving, and you're obviously taking a lot of pains to do the process the right way because of the importance of the issues. And I'm kind of thinking if it isn't broke, don't fix it. Me personally. So.
But we do like the fines. I think we're one of the...
Well, we can talk about, those issues. The sentencing and the fines, I think, is legit. But the process, to me, I think you guys are doing a good job with.
Peggy?
Yeah, I agree with Bruce, and it is important, I think, for the public to see this. That may encourage other people when they see this to behave themselves. The issue of the witnesses, if it's a sting, and I understand, I think the night that I was there were cases involving, in the sting operation, they used some students from colleges, maybe CSU or someplace. Surely there must be some local people that could be used so you don't have to bring somebody back from college or whatever to do this. There are a jillion young people that probably have, well, not a jillion, but quite a few of that jillion who have good relationship with the police who would participate in a sting operation. So again,
Well, they only have to be under 21, that's really
Yeah.
the only requirement.
and in the one
Be
case,
willing to do that.
see, not having children.
And give up the liquor after they leave.
But not having children and not having grown up in Colorado, I didn't know about the two kinds of orientations of licenses, driver's licenses. And the one case was the underage license, which has a totally different orientation, and yet somebody seemed to think that that was an of-age person. And something that obvious, it seems to me, be nice for the public to know, and maybe even people who are working in liquor stores to be reminded, this is an obvious violation. Don't be so stupid here. So I kind of like keeping what we have unless the board, the authority thinks that we should be changing it.
Jim?
Well, it's been many, many years since I served on Liquor Licensing Authority, but having dealt with underage drinkers was more black and white than what it is getting to deal with intoxicated people that's being served. Those were the more difficult cases to me. To me, whatever you can do to make it more efficient for the authority to operate with would be my preference, but I'm willing to do whatever you guys would prefer having done. If you want to continue like it is, going through all the things you're going through now, that's fine. If you want to see steps taken to shorten that process, I can certainly support that too. But I would be looking to you guys to what you would like to have done.
I think what we've done and seen since the establishment of the authority, with different members coming and going, has been very consistent. I do not believe that this authority has ever wielded its authority for authority's sake. We've been extremely business-friendly, conscious that these folks are running a business and they need to make a living and feed their families and have housing, etc. What I have seen occur is this authority watch and impose penalties, but hold things in abeyance. People don't come back. We see the violations start to creep up. We start to impose a little harsher penalties, and we see the violations come back. So if you are looking for outcome-based results, I think this authority, since its inception, has really done an excellent job. And I appreciate the idea of the efficiencies very much. But as you can tell, there is not that many cases coming before us of this nature. And so I think the monies involved are really minimal for the city.
I think I'm very much in favor of compromise that Phil proposed, which would add some efficiency to it, but still give the authority the tools to impose the penalties, even if we disagree with a suggested penalty, or if we have to make a change, it's not like you have a written document signed by all parties that you have to open back up to make a change to. And I think it's important that we have that authority to impose the penalties.
I guess I don't think that there's really a necessity for a preliminary hearing. I mean, I think the way it has been working has been working. And I think more people will come to a stipulation as to violation because, as Andrew said, they're pretty straightforward. You know, the stings are pretty straightforward. And then the hearings are not very formal. So, I mean, it's adding another layer that I just don't think is necessary. But
I guess I'm inclined to agree with Bruce that if it ain't broke, don't fix it. And given the number of cases that we have, I'm not sure that we're going to gain that much efficiency. However, I think that selling liquor is a serious business. I'm especially concerned with selling to underage. We've had teenagers killed in the past that have gotten obtained liquor from Littleton liquor stores that then went out. I'm thinking of the 5 kids that died down on Titan Road. So I consider selling to underage to be a pretty serious affair, and they better have very mitigating circumstances for you guys to be lenient with them. Because I don't think that we want selling of liquor to underage kids to be an issue in Littleton. But the reason why we point you guys is to look at what the cases are, to come to a intelligent, rational, reasonable decision on what you think the penalty is. We expect you to look at what the previous cases are and take that into account. I think you're doing that. Given the volume of the cases, I'm not sure that it really justifies a big change. At least that's my opinion.
So we can go back to just doing oral steps and see how many people want to do that or go to hearing.
Okay, what about the fine stuff?
So fines in lieu, that would require an ordinance, and that would be where there was actually a suspension. So like a 10 days, maybe 7 held in abeyance with 3 days to serve. A fine in lieu provides a mechanism where a business could choose to pay a fine in lieu of serving the suspension. And I think in general they pay 20%. Do you know, Rochelle? It's 20% of...
20% of whatever their sales were for the days that they were suspended.
Right. So
Going to
then...
be suspended.
Yeah, so then they would come back to the city and pay that fine amount rather than serve the suspension. It would require an ordinance.
It didn't intend to, I had citizen input on this issue, but it was somewhat accidental. I had coffee this morning with David Svensson, who owns Merle's, and we started talking about this issue. And his view, and I just throw it on the table as someone who's obviously a stakeholder and has experience in the business, was his feeling with the fine structure is that it should be a substantial fine up front, followed by suspensions without so many necessarily intervening steps. I don't remember if it was Centennial or Thornton had more or less 5 strikes and you're out kind of thing. And he felt that it should be much more of a deterrent with a fine up front if we were going to go that route. I just throw that out because it was citizen input from an informed individual. So, but I think the fine structure itself, certainly imposing a fine at your guys' discretion, if it's something you're willing to do after looking at the totality of the facts and the hearing, to me, I think is certainly reasonable as a tool to have in the toolbox.
Well, I think a fine is just an additional tool that we would have, because fine is going to be a lot less severe on a business than a suspension.
Depends on the magnitude.
It's financial, but a suspension with the posting of a notice and the closing of business and the loss of customers can be incredible. Sometimes we like to stop short of that on a first offense, and we haven't had that option in the past. So I would definitely be in favor of a fine in lieu of suspension.
Well, I guess I'm going to be the Neanderthal here, but I like the fact that they have to post a sign that the public knows that they have violated, that they have to close the shop for whatever the period of time is. Once again, I realize that people are in business to make money on this, but But the reason why we have liquor laws and control the sale is to prevent accidents from happening and kids from getting it and things like this. And if they're going to take this business on, I think they need to be responsible for the conduct of their business. So if we go to fines, my concern would be that we end up using fines as a way of softening the blow to softening the penalty for actions that they've taken. And I recognize that there's all sorts of mitigating circumstances. I've heard from a number of different owners of restaurants with bars or bars whose complaint is they feel caught in a catch-22 because if they have a problem in the bar and they call the police to fix the problem, then they get hauled in for the liquor authority for a liquor violation, and so they feel like, they're kind of pressured to not call the police, which makes the problem kind of escalate. So I recognize that there's mitigating issues and there are difficulties with running the business, but it is a serious business. And frankly, if you've got a liquor store that's taking a guy from the back room and burning the cash register and he doesn't know how to do it, then that's a pretty bad decision on their part.
Actually, in that case, what we looked at more was the changes they had made so that it would never happen again.
And that I can buy. If they've gone and invested money to try and prevent that from taking place by getting a reader, I think that is a reasonable solution, and that indicates that they take that pretty seriously. So in that case, that's probably a good judgment from the little bit that I know about the case. But if we go to fines, I'm sensitive. I'm concerned about using the fines as a way of lessening whatever the penalty is. Now, there may be circumstances, like you say, where there is a very minor offense, it's a first-time offense, you think that they're very responsible people, and then maybe the appropriate thing is to do a fine. But I would be disappointed to see very many fines in lieu of penalties, unless we have a whole rash of first-time business owners that are making singular mistakes that come before us.
Well, I think that it's significant that we're talking about the first-time offense and not a series of offenses. The first-time offense, is my understanding, that's the only time that we would have the discretion to apply a fine or not. And then we would look at the circumstance. If it was something, extremely serious, I think that we would definitely, look at whether to give them a fine or to give them, a sentence in abeyance or to have them closed down for a certain amount of time. So it's not kind of a blanket. It would be on a case-by-case basis.
Okay, I guess I can accept a fine for a first-time offense under the discretion of the licensing authority.
I think it could track the statute. There's a statute, and I think when I was looking at how the other city and county liquor commissions worked, we're like one of the only ones that doesn't utilize fines at this point. And I think mostly when the city has drafted an ordinance, they followed the statute. And in that case, they still have to have a hearing, and there has to be a violation. So there would still be that public aspect of it.
Can we make the ordinance for first-time offenses only?
We can.
I would second being in a position to see that. I think it gives you some discretion, but I would like to echo some of the mayor's comments in that a violation is serious. And you're there to offer that discretion, but recognize that if there's the risk that something goes wrong in the community with even a single violation. And it is part of the business that folks take on in this. And I just know in a lot of other areas, there's, even at a single offense, there's not a whole lot of forgiving that happens because it could be someone's livelihood, could be someone's life that is taken. And that's why you're here, to make those weighty comments, and so I would echo the comment, which is,
I think, oh, I'm sorry.
yeah, don't take them lightly.
Well, I was just going to say, I think the message comes through loud and clear to the authority that it should be rare that we impose a fine in lieu of a suspension rather than the common occurrence or the majority occurrence, because we understand the sense that the council has that we are not here to give people a break, but we can appreciate the fact that we would have one additional tool in one of those situations. There's almost never a situation in a underage serving that is really vague. It's the disturbances and who called the police and when did they call that.
And how intoxicated they
it's
were.
really easy to understand somebody's position and the over-serving of somebody that doesn't seem drunk until they get in a fight. Things like that are harder to detect. And on a first offense, I think that's an example of how we would use that.
I suppose it's always good to have another tool, but I think we would be wise to consider the public perception of this, and just from a different perspective, if you do have a first-time offense, say a 3-day suspension, what would be a 3-day suspension, instead you get to pay a fine, which is 20% of the sales over those 3 days. I mean, the other way to look at it is that's an 80% reduction in your penalty, financially 80%, and in some sense even more so because you don't have to go through the, people walking up to your store and having to walk away. So I just think we'd be wise to consider the public perception. Will it look like people are allowed to pay to get out of what they otherwise ought to be serving?
Bruce? Well, I was just going to ask, I guess, a question under the revenue statute. Donovan pointed this out, and I think it's a fair question. The memo, Suzanne, the last bullet there talks about expected loss of gross income from the sales of alcoholic beverages. Does the statute define that as basically sales revenue, the way Andrew just described it, which is essentially what I think we're trying to do? Okay, it's supposed to be sales
Gross
revenue.
sales.
Gross sales. Okay, because gross income, yeah, would be net of something.
Right, it's
Okay.
gross sale,
Perfect.
receipts.
Debbie?
I totally hear your point on the fine situation. And there's a balance between first offenders and repeat offenders. I mean, there's somebody didn't learn their lesson and somebody else is going to learn their lesson. One of the things that concerns me a bit as I go through, when I look at the suspensions, is how many of them are held in abeyance. Is that the word, abeyance? And how few really do end up closing their doors for even a day. And I wonder, a fine, 20% may be a wrist slap, but it seems to me suspensions with the abeyance on it there's no penalty, there's no punitiveness at all. I mean, it's like, what is the motivation not to do it again is if you do it again, then you do have to serve those, I suppose. But it just, it's almost like your first get out of jail free card. So that, I don't know, maybe you can explain some of why those occur as frequently as they do, and you guys use that as a tool. But if it was a difference between that and on a first occurrence and putting down a substantial fine, I'd probably go with whatever hurt most.
Well, except for that there's an incentive for them not to do it again within the year. For instance, if you do a 5-day suspension and hold it in abeyance, if they violate it again, not only do they have to serve the 5 days, but we have the second violation, and we've had that before.
But I guess my feeling is that it is a it is a tool to not have them back in there within 12 months, but it is not a punishment at the time.
No.
It's like you can get grounded, but if you also get spanked, you know, well, I used to get both.
We
A lot.
We try to always have some suspension reserved. We make it our thinking is we make it a bigger number in total and always have them serve some number of days. 1 day, 2 days out of 5, 3 days out of 7, something like that. So that they're penalized having to serve some time right now. But the big hammer is if they come back, because they serve all the time that was held in abeyance this time, plus a new suspension for the second offense. But we try not to ever have all of a suspension held in abeyance, so that they do have to close for some period of time. Might only be a day, but I think in my experience it's been mostly a couple of days.
And again, what we've looked at, because I certainly understand what you're saying, Councilman Brinkman, but what the authority has looked at, once again, is outcome. And if you'll take a look at the number of establishments that we then have imposed, as the chair points out, a larger number, but left a number of those days in abeyance out there as an incentive, you do not see those liquor establishments coming back within the first or the second year. And these business owners communicate among themselves. Perhaps Councilman Verheul can speak to the business community. Business folks talk. And the word gets out that this is what's happened, and what we're seeing is we're not having repeat offenders come in. When we do, we get significantly more harsh. There's one individual, if there's suspension, they're no longer in business. They're gone.
Peggy and then Phil.
Yeah, I have a question. If you have the suspension and you defer some, but you do have part of those days, can you stipulate that those days might include a weekend? I'm sort of thinking of like when somebody's grounded. If you're grounded and nothing the devil's going on in your life, what difference does the grounding mean? So if you got suspended on Tuesday and Wednesday, or Monday, Tuesday, or whatever the slow days are, so what?
We have the power to make those days be any days that we want. We try to work with the licensee to fit into their schedule. Bars, we hate to close them down on Saturday, Friday and Saturday, unless it's really a severe situation. We give them a chance to give us input as far as when they would be the least hurt by that.
But if they violated something, shouldn't they be hurt?
I think they're hurt no matter what day of the week it is. But if it's a first violation, we really do try to work with them. We're cognizant of the fact that they're businesses too, and if this is the first time in front of us.
So you might do something different, though, if it was a second. Because my question isn't just on the first, but on...
If it's a second, it's generally a week. It could be a week, and then it's going to include all the days.
That's a discretionary thing. I'm recalling when I was interviewed by the city council for the position on the authority, and one of the points I was asked to keep in mind at all times is that you're affecting somebody's livelihood here, and you have to be wise in your decisions and your penalties. And I've always kept that in mind.
It seems me mighty kind to have that, not of you, of whoever's saying that to you. They didn't have to let the violation occur. And I think the idea is to try to say to people, cultivate the right employee situation, the right business situation, it's not like it's an accident. I mean, in my view, it's not. So I guess
It works both ways. If we are too lenient by allowing them to give us input and they pick their worst days to be closed, that's not a good thing. But if we go out of our way to find the days that will hurt them the most,
yeah, well, I didn't mean necessarily
that's the
that,
other
but
extreme, and that's
yeah. I just think if it's a penalty, it should be something that they feel. But should they be put out of business? Not unless we've got some ongoing problem, I guess.
Peggy, it sounds like you were grounded from 10 o'clock at night until 8 o'clock in the morning.
I always behave, so I don't.
Phil? At least one thing we could consider, knowing there are other jurisdictions that certainly have fines in lieu as part of their tool chest, would be to put a sunset on it that says, hey, put it in for 2 years. And if the authority comes back after 2 years and says, you know, we really haven't used that, we don't really need it, that would be okay too.
Jose?
Thank you. I have to kind of sit here and wonder as to how many people here have liquor licenses, how many have businesses, because it's quite a funny thing to have all of this come down and all the rules and regulations that we in business have to follow. The fines are okay with me. And Peggy, you were saying, well, you know, why do these policemen pick somebody from out of town? It might be a good thing because of the fact if you had your son running around here and all of a sudden everybody found out this kid is the one that was doing the snitching here. It reminds me of a story that happened over here on Bellevue and Windermere on a sting. They sent this kid in there, and it was a restaurant at the time and bar. And they checked his ID, and he failed. He didn't have the age. So he went out and he came back and he tried again. So these two bartenders grabbed him, they took him downstairs, locked him in the cooler. So about 15, 20 minutes later, the cops come in looking for this kid, and they said, we know he's in here somewhere. He said, well, we had a kid in here that was trying to buy booze. He wasn't old enough. He said, we'll take you down to him. So they took him downstairs and unlocked the cooler, and the kid was pretty cold by then. But that's one reason, you know, you might want somebody from out of town because it might be your son. But the fact is that you have to be very, very careful about these things. I know that many licensed businesses, the trouble that starts in there doesn't even start there. It starts at home. I've had people come in, you know, very gracious, very loving couple, and sit there for about 20 minutes and start slapping each other around. You call the cops and you're on the list. They would say, well, why didn't you take care of that situation? Well, you know, you can't be all things to everybody. And it's the same way with kids. Kids do stupid things. And I think most generally after they get the first round done, they usually have learned a lot about liquor licenses and what it does to people, how it affects a business. And it's true, you know, you lock a guy down for 5 days. You know, you're looking at a lot of lost revenue to the city, but also once you post that on the business, you know, there's a bad mark on a guy, especially me. I wouldn't want it, you know. So we've been fortunate in all these years not to have it, but I've seen people that have come in and they're intoxicated. How do you know they're intoxicated? I mean, we have to just kind of take a chance. We tell them, hey, you can sit down and have something, but it's going to be coffee. That's it. And of course, you've got to throw them out because of the fact that they don't want coffee. So you've got to handle this very delicately in every situation. I've had a full table of 8 people. 6 were adults and 2 were teenagers. Ordered margaritas, and the girl comes back and says, you know, those people are passing the margaritas over to those kids. So I told them, go out and ask them to, they can't do that. It's against the law to do that. So girls got their orders come in, and she says, you know, that people are still out there passing those things, margaritas over to these kids. I said, about that time, their order came up. So I said, I want all the waitresses that I had. We're all going to take two plates apiece, and we're going to set it down in front of these people. And so what I did was we went out, we set the food down, and oh, they were so happy. They were very glad they got their meal so quick. And I said, now girls, pick them up. And they said, why do you pick them up? I said, because you don't give a damn about my license. I can lose my business because you don't put any discipline on your kids. And that's sometimes it's the adults that are causing this problem. So it's not always just the kids. So that's one way we took care of it, and we just never let them come back again. I said, just go out the door and don't come back. So the whole business of being in the liquor license, having a liquor license, it's not an easy business because most of the problems that occur are just by individuals going in, and they sit down and they might have been drinking somewhere else. You don't know. And it used to be that when they wanted to, when you could, before the tort law came in, they'd take your whole damn business away from you. You could get fined that much. So I'm happy that the commission is dealing with things as they are. I'm happy about it. But I'd like for you people to come in sometime and run the place for a while and let me go out and go drinking. But anyway, I see good things in all of the businesses, and you just have to be very careful about everything. Thank you.
All right. Sounds like we're going to ask you to bring an ordinance back with fine for first offense.
Okay.
And then you all try that out. If you think the fine is inappropriate, or if you come back and think that we need to do it for more than just a first offense, come back and tell us. But let's try it out for a while. Is that all right? Okay.
Thank
You want a motion on that?
Yeah. Why don't you go ahead, Peggy?
Oh, dear. I move that the city attorney draft an ordinance that would provide a fine for first offense liquor licensing authority violations. Is this going to be also to cover the marijuana stuff? No. Okay, so liquor violations.
I'll second that. Discussion? All in favor, raise your hands. Unanimous. Anything else?
Just the cost. Do you want us to do a cost study and bring you back a resolution for costs, or are you not interested in costs on hearings?
First one's costs.
Second.
Okay. It's been moved that you bring us back a study on costs.
So that's just a study, not a motion? I mean, not a proposal?
Once you come back to us, how would we implement the cost? By resolution or?
It would be by resolution. So I could just bring the resolution with the study attached, and then you could decide what you wanted to do with it.
No sense in doing it twice.
Yeah.
So can I ask a question? So if we have costs for show cause hearings, what if you decide not to, if they decide not to, that someone doesn't have I'm not saying this right, but if something doesn't go past the show cause piece, then costs still have to be paid?
Costs would be paid anytime that they admitted to the violation or they were found to be in violation. Costs would not be assessed if they were not in violation after going through a hearing, and costs would not be assessed if they chose to change ownership prior to the hearing. Then it would be a different set of costs. So sometimes we have a hearing set and the person will just call and say, I'm relinquishing, and then they would transfer ownership, and that would be a totally separate process.
Okay, the motion is to bring back a resolution for costs. Discussion? If we do that, then my guess is the licensing authority is going to take into account what the costs are in addition to the other penalties. So I'm not sure that we buy ourselves all that much, but
I think they have they can implement as much as they want without a problem. I think it would just be another layer on top of what we have with them. I would vote against this.
I think what you basically are doing is transferring probably a day of penalty into a revenue stream for the city. Further discussion? All in favor of
Excuse me, could we ask the authority if they have a thought on this?
authority? Do you have a thought on this?
I really don't like the idea of imposing the cost. For one thing, I don't have an understanding how we come up with the cost. We can certainly do that.
It would be a set standard. So we would study other jurisdictions, much like we assess court costs. Any defendant who comes into court pays $20 or whatever it is. We would have any person who comes in on a show cause hearing pay $50 or whatever it is based on a study of what other jurisdictions are charging. It would be a set cost for the hearing.
And then would they be billed for the cost by the city, or would they pay the cost at the end of the hearing, or?
They'd pay it to the clerk's office.
So they'd pay the city at a later date. I don't have any problem with that.
Andrew?
Oh, so the idea, it's a fee, right? Because they're requiring a service of the city, which is to investigate their violation. Would there be any discretion?
I think you could waive it under, like you can waive any fee under some kind of extenuating circumstances.
And it's only if they either stipulate or they're found guilty.
So when this would be brought to us, could you float it past the authority too, so they would know it when it's coming and they could give comments to us?
We can do that one and the fine in lieu. Take it to them first.
Thank you.
Well, I guess my only other thought would be, so if someone comes in and says, yes, that happened, so say it's a sting, someone comes in and says, yes, I don't dispute the facts, and it takes little time other than, I guess, the officers in the reports they would have had to make. We're finding them on it's a scale, but we're still assessing a fee to them the same way we would to someone who says, I want a show cause hearing and I want to bring in all the, is that the idea?
Yeah, and it's difficult to do it any other way because then in essence you get into penalizing someone for exercising their right to a hearing. So it's safer to set them all at the same.
Susan?
I agree with that. I mean, whenever you go to court, you pay the cost, so.
Victoria?
When you go to court, you pay costs. It shouldn't be any different.
I'm neutral about it, but it certainly does not sound unreasonable.
Okay. Council ready to vote? All in favor of having the staff bring back a resolution for costs, raise your hands. Okay, it's 5-2 with Jose and myself voting against it. Anything else?
No?